Okay, here we go. All right. All right, thanks everyone for joining us. This is going to be a very interesting talk. I've known Ruth for a couple of years now, but have never really heard her speak on this subject, so I'm really looking forward to it. I think many of you know Ruth Mariampolski. She is an attorney. Esquire after her name indicates that. And she is here to explain how to read a Supreme Court case. And with that, I will let Ruth take it away.
Thank you, and thank you all for having me. I'm following two very difficult acts to follow, and my presentation is a little bit more dry, but I hope that you'll all enjoy it. One reason why I'm offering this talk is because, as we know, decisions of the Supreme Court can affect the everyday lives of all Americans, but the law has a lot of traditional and historical ways of communicating that are very non-obvious. Lawyers receive extensive training in law school about how to read and understand court cases. And my goal for this training is to help all of you recognize and navigate through some of the different traditional elements of a Supreme Court decision. So just to be clear, I will not be discussing the substantive content of any case today. So I'll just be talking about shall we say, the geography or the anatomy of a Supreme Court case. So I've got quite a bit to present, so I'm going to jump right in, and hopefully we have time for some questions at the end. Okay. So the first thing I want to put forward is, you may be wondering, where do I even find Supreme Court opinions? The good news is they're actually fairly widely available. Bound volumes are found in many academic and public libraries, and when you look over here at the little image I've provided, you may recognize those tan, red, and black volumes from the backgrounds of many legal TV shows. There's also paid legal research databases. Hey, my slide got a little messed up, but one of them is called Lexis and one is called Westlaw. They are both subscription services, and the Donnelly Library has a Lexis subscription that you can use. There's also free legal research databases. Two of the most prominent for Supreme Court cases is the Cornell Law School Legal Information Institute and a website called oye.org. And then finally, at supremecourt.gov, you can see pretty much all the recent opinions and other information about what's happening in the Supreme Court. So the first question that you're going to want to ask yourself when you think you're looking at a Supreme Court case is, what version am I looking at? There's three flavors of publication. The first is called the slip opinion, and traditionally it was a pamphlet published to communicate the decision to the public. But being published at supremecourt.gov is the modern equivalent. There's also something called an unofficial reporter. And in the United States, our unofficial reporter is called the Supreme Court reporter. And if you see, I've listed what the citation looks like. It's just one of the biggest hints that you're looking at the unofficial reporter and not the official reporter. It will say like sup.ct in the middle, Supreme Court. The official reporter is the United States reporter, and the citation has US in the center. So those are the three kinds of opinions. Next question is, what's the difference? Why is it important? Usually the difference between the versions is very minor, but if the official reporter is available, it is best to read that version and refer to that version. First of all, sometimes there are typos that are small but significant. And I've highlighted here, there's a 1928 slip opinion that contained a typo in which properly was wrongly written as property. The wrong version has been cited in 14 cases, and most embarrassingly, in an argument before the Supreme Court. So obviously you guys are not in a position to be embarrassed by situations like that, but you can see that errors creep in when you refer to the slip opinion. sometimes the versions are actually quite different. It may be very surprising to all of you that until 2015, the justices were not required to announce a change in their conclusion. So only recently, really for like 7 years, all substantive changes, which is a change to the substance of what was decided as opposed to a typo, all changes are announced. But in the past, that was not the case. So if you're looking at a decision that was written prior to 2015, make sure that you are looking at the official version, the one with US in the center of the citation. Okay, so now we're going to think about what are the parts of a decision. And these are the parts that you'll generally see consistently, and there's some things that have variations, but these elements are generally going to be consistent. So the first thing you'll see at the top of a decision is a summary, which is called a syllabus. The syllabus is always labeled as stating, this is no part of the opinion. A summary cannot be cited for legal precedent. It is, usually written by someone other than the justice. It's usually either written by the justice's clerk, which is their legal assistant, or sometimes by a specific office within the Supreme Court that writes syllabi. And this is just a first little hint that some of the legal vocabulary means very different things than what we might be more familiar with in the academic context. So I guess technically academic syllabus for one of your classes is also a type of summary, but syllabus in the context of a Supreme Court case is a summary that appears at the top. The opinion of the majority starts at the byline. The byline is always phrased as Justice so-and-so delivered the opinion of the court. That's how you know the majority opinion is starting. So in this case, I wrote Justice Kennedy delivered the opinion of the court. Usually, typically, the first thing that will be discussed in the decision is the procedural history. They will talk about who the lower court was, what they ruled. Sometimes they'll go into the rationale, what appeals occurred, and basically how the case arrived at the Supreme Court. Then there will follow a large text, which is considered the body text or the reasoning. And it will finish with what the legal vocabulary term is the disposition, which is what the court orders to happen next. It isn't usually its own section, but it's usually the last thing that is discussed before the finale line, which is, it is so ordered. This declaration is where the majority opinion ends. So you're reading from Justice X delivered the opinion of the court to it is so ordered. That is the majority opinion. Finally, after it is so ordered, other opinions will be presented. If there are multiple opinions, they are presented in the following order: majority, then concurrence, then dissent, and we'll discuss what all those terms mean. Whew, I feel like I'm racing. Carol, am I speaking too fast? It's okay, she says. Okay, so what are the opinion types? We've got the majority opinion, which I was just discussing. This is the binding opinion and the reasoning. The opinion and reasoning that states the law. One justice writes for the majority, as I mentioned, that person is named as the author at the top of the decision. Then there are something called concurring opinions. Concurring opinions are written by justices who agree with the ultimate conclusion, but for a different reason. They may write their own concurring opinion, which is called a concurrence. And I will highlight here, again, from a vocabulary perspective, that I concur has a different legal meaning than common meaning. Generally speaking, when someone says I concur in general speech, it means I agree completely. It almost means something directly opposite in legal vocabulary. It means the other person is using the wrong reasoning. So concurring opinions, they are kind of offer the justices an opportunity to share their own thinking and rationale. Finally, we will have dissenting opinions. Justices who disagree with the conclusion and the reasoning, they may write a dissent explaining why. Some dissents become very influential over time, and the main reason they're presented is that they can be cited to argue for changes in the law, right? You may say, like, in the future that, oh, well, there was this dissenting opinion and we should go with the dissenting opinion because the dissenting opinion was more correct, now that we've seen all these things that have happened. Next, we're going to discuss the different kinds of dispositions. Dispositions, as I mentioned earlier, are what the court decided should be done. Okay, the three most common ones you're going to see affirmed, reversed, and remanded. Affirmed means we agree with the lower court and confirm their decision was correct. I just want to say before I continue that it's very important to understand that the Supreme Court only hears cases and controversies that actually exist. It does not give advice about what would or wouldn't be legal in a hypothetical. So a case always arises from a lower court to the Supreme Court. That's the only way it can get there. Well, there's tiny exceptions. We're not going to worry about those. So in the case of the term affirmed, they're saying, yeah, the lower court was right. We're going to go with their decision. Reversed means we reject the opinion of the lower court and we rule the opposite. I think that's somewhat self-explanatory. Finally, you may see remanded. Remanded means we send the matter back to a lower court to apply the new rule we established to the facts or for a new trial. And basically, the Supreme Court cannot change the factual findings of a jury or a bench trial judge because they're allowed to rule on the law, not on the facts. They can only state the correct legal principles that should be applied. So if the original reasoning is found faulty, sometimes it's not enough to simply reverse the decision. If the fact finder, the jury or the judge in a bench trial, used the wrong legal principles to evaluate the evidence. Instead, the case must be reconsidered from the ground up, so it goes back for a do-over, a new trial. I will note that remanded does not guarantee a different result. The only thing it does is basically say that the law should be considered in a specifically different way than it was. So basically, as you can imagine, some kinds of cases, and it's very common in criminal cases, that the case has to be remanded because the problem was interpretation of the evidence. So there's different kinds of issues that the court may hear. Again, you may see affirmed, reversed, remanded. You may see reversed and remanded sometimes. Now, occasionally, now we're starting to get into to dig a little deeper. Sometimes instead of an author's name at the top of a majority opinion, you'll see the words per curiam. Per curiam means by the court. A per curiam decision has no author identified. They are usually less significant matters, but not always. And Bush v. Gore, the case of the Florida election recount, is probably the most well-known per curiam opinion. Now, it's very interesting that per curiam does not mean unanimous. It means there was actually 1 concurrence and 5 dissents in Bush v. Gore. There was like a ton of varied opinions on that situation. So for whatever reason, sometimes they choose not to identify a justice as the author of a case. And then you'll see per curiam. That's, one of those mysterious terms that one of the reasons why I'm giving this talk is because those terms can be very mysterious. And there's a lot of old-fashioned language, unique vocabulary, and also Latin sprinkled liberally. There is a book called Black's Law Dictionary, where if you're reading along and you might see some Latin terms or unfamiliar words, that's where you would go. It's a specialized dictionary for law. And it comes in a paperback, and I'm imagining that Donnelly Library has multiple copies. So the next thing I want to highlight is how you read a legal citation. Now, let me interject before I begin discussing this slide with when you're reading about the law and about Supreme Court cases in the media, the reporting is not great. And the number one thing that it will be hard to find is sometimes you might be reading like an analysis of a case or an op-ed. They will be, for some reason, reluctant to identify the actual citation of the case that they are talking about. But by using those other websites like supremecourt.gov and oye.org, you may be able to hunt it down. It can be very, very frustrating to hear people talking about legal matters and you're trying to go to the original source and see what they're talking about. And sometimes it's difficult. So anyways, that's just a little editorial remark. So here are the parts of a Supreme Court legal citation. The first number is the book volume. Remember I showed you how they're bound in books. That's the book volume, 539. The reporter is the little code in the middle. You always want to choose US if it's available because it's the official reporter, but you might see slip op or you might see SUPCT. The next, the next number, this one here, is the first page within the volume of the decision. So what you're going to do is you're going to pull down volume 539 and you're going to open it to page 558. And that's where the decision will begin. The next number, if it's followed by a comma, is what we call a pin cite or a pinpoint citation. It is never correct in legal citation schema to broadly cite to an entire work. You're supposed to use pinpoint citations to show if you're making say like, in such and such case, the court ruled, that the court ruled something, and you want to cite to that idea, which we call a proposition. You need to find the page in which the court ruled and use that exact page in the location where we call pin cite. So as a reader, if you're seeing a pin cite and it's saying like something that you may find to be controversial, for example, you can go exactly to the page and see exactly what it says. And then last but not least, you'll see the year of publication. Having, in general, in citation, the court and year is always presented in parentheses. But in the Supreme Court, since there's only one, you just put the year. If you only see a year, you're generally looking at a Supreme Court case. This is the basics of the information you can glean from a legal citation to a Supreme Court case. And generally speaking, the name of the case, A versus B, will precede these numbers. Then someone may say, but I want to know so much more about legal citation. I'm just a nerd like that. So there's a book, it's called the Blue Book. Every lawyer has one. It's the legal citation manual. In contrast to some kinds of citation manual that you may be more familiar with, it doesn't offer general guidance and it isn't a style manual. It's not like the Chicago Manual of Style or the AP Style Guide or the MLA citation manual or some that you guys might be familiar with. It is literally 400 pages of incredibly specific instructions, and it's in microscopic type. It covers citation situations that are extremely rare. As in one example, it has very specific instructions on how to cite to the Constitution of Austria. I think you can imagine how often people need to cite to the Constitution of Austria, which is not very often. Yet the Blue Book contains all these instructions. But one thing that the Blue Book is actually good for the casual reader is it explains what all the abbreviations can be in lengthy citations. So if you see an unfamiliar abbreviated source name, it's probably the #1 place where you can look up the name of the publication. So here I've given an example. This series of abbreviations stands for the Rocky Mountain Mineral Law Institute. You know, that is, again, a lot of people, they might be reading something, they may want to go to the original source. And a lot of times these are journal articles or other types of periodicals, and they're kind of obscure or not widely published outside of academic legal circles. But the Blue Book contains a very lengthy list of virtually every periodical published in the United States and how to abbreviate it. So basically, it can be a good source for a reader if you're struggling to locate the original source. Obviously, your librarians are an amazing resource, but this is just an idea to put out there. Finally, or not almost finally, I really did race a little bit, but many people are asking, but where can I find like more information about Supreme Court cases? There is a not-for-profit website. It's called Oyez. And the reason it's called that is that perhaps some of you, whether having been in a court or watched it on TV, heard someone announce, "Hear ye, hear ye," as a way of opening the court session. Well, the Supreme Court takes it to the next level and uses the traditional French for "hear ye," which is "Oyez," hear me, or everybody hear. It's an imperative statement. So just to give you, almost like a flavor of how deeply steeped in tradition the Supreme Court can be and how old-fashioned, they don't even use English to open their court. They use Norman French. So that's a little crazy and can kind of give you some perspective. But Oyez.org collects all kinds of background material for Supreme Court cases. You can listen to the recordings of the oral arguments, information about the lower court rulings, the names of the lawyers who participated, decision dates, so much more. And it's presented in a much easier to navigate format than on supremecourt.gov, which sometimes assumes that you are in the legal profession, whereas Oyez.org is really for the non-lawyer reader and organizes things in a very easy to understand way. So if you ever wanted to take a deep dive into something you read about on the news, Oyez is probably your #1 stop. It's the best organized, it's the most comprehensive. And I really want to highlight something they do that's incredibly useful, that is sometimes hard to pick out from a case, again, if you're not experienced in reading them. They provide a clear statement of the question or questions the Supreme Court sought to answer in hearing the appeal. Remember when I said that they hear only cases and controversies, but never give advice? So a case comes to them with a specific question to be answered. And Oyez does a really good job of expressing what is the specific question that was to be answered. So when a person wants to appeal to the Supreme Court, in most cases, in the majority of cases, they have to submit a writ of certiorari, which is a historical name for an application for appeal. Again, we have excessive Latinism, but this term has the same Latin root as certified, and sometimes the question is called the certified question. So that you may hear that term, the certified question was. They don't use that term on Oyez, but they do really, sometimes cases come to the Supreme Court with only one question to be answered. Sometimes cases come to the Supreme Court with many questions to be answered. So Oyez has a really great way of organizing that information and can really provide you with incredible background. It's an incredible organization. I know I'm hyping them. By the way, Cornell Legal Information Institute is also really amazing, but isn't specific to the Supreme Court. So that covers like lots and lots and lots of different areas of law, whereas Oyez is specific. So that's the material I wanted to cover. And thank you for coming to my HU talk. I've been wanting to say that all week. If there anyone with questions or wants to re-review one of my slides, if you didn't have enough time to pass through it, I'm also more than happy to circulate this slide deck. I killed you all with information, like giving you a drink from a fire hose.
So Ruth, I have a question for you.
Yes.
Can you talk about how these cases can be informative for folks who are supporting or not supporting a piece of legislation that might be coming up, in terms of how, informing them about the subject matter and reading the different opinions and so on? Because I don't think people normally think of looking at Supreme Court cases as great reference material for activism, so to speak.
Right. Okay. So a couple different elements to my answer. One is that always remember that the legislative and the judicial are separate in their sovereignty, and they don't tell the other directly what to do. But the Supreme Court is the one with the authority to say whether a law is legal or not, constitutional, essentially. So what you often have is a Supreme Court saying, this law that we were presented is legal. If you want it changed, you need a legislative action. So a really good example of that occurred in the Fair Pay Act. There was a case. The plaintiff was a woman named Lily Ledbetter, and basically, she didn't find out that she wasn't being paid equally to male employees until a lot of time had passed in her employment. And the Supreme Court said, well, the Fair Pay Act, as it is currently written, says that there is a time limit. And the fact that she didn't learn of the differential in pay until much later, well, that's a fault in the way the law is written. If you want it to be different, legislator, you have to change the way the law is written. Well, they did turn around and they revised the law in what's called the Lily Ledbetter Fair Pay Amendment, and they literally fixed the mistake that the Supreme Court identified. And that is each operating in their sphere, right? So when you have a Supreme Court case saying there's a fault in the way the law is written requires this result. Now, obviously, differing people can differ on that, but under our constitutional system, some might say that the fundamental question is who decides. And the answer that has built up over the years, starting with the case of Marbury versus Madison, is the Supreme Court decides. They have the last word on whether a law that's written is constitutional or how to apply it. So when you're reading, you're building your advocacy for a certain result, and you want to advocate in the legislature, you need to know what the Supreme Court has said about current or past incarnations of the law, because they may have said this law requires revision if you want a different result, something like that. And that's, like I said, in the case of the Fair Pay Act, that is an example of where they did that. Now, again, I'm not trying to, talk about specific issues, but there have been different times when the Supreme Court has said, this is not a federal issue. This is an issue that should be decided by individual state legislatures. And that also is a driver for advocacy, because if a matter needs to be decided by state legislatures, that means that you need to advocate to the right legislatures about how laws should be written and enshrined. And now we're kind of digging deep into the separate powers of the federal and state government, which is a very complicated topic, usually worthy of an at least semester-long class in law school. Basically, if the Supreme, you may disagree with their conclusions, which any citizen has the right to do, but to get a change in the law, you essentially have to follow the path that they've laid out for how the law should be created or maintained. You know, I'm trying to think of different examples. Of course, I didn't necessarily prepare, but that is for advocates, having a clear understanding of the rationale and reasoning that the Supreme Court used to come to a decision that you want to advocate for a legislative change. It can be very important, because what legislatures don't want to do is write a law that will be immediately overturned because it's directly contrary to something the Supreme Court has already said, right? So you want to be within the field of where you're advocating. You want to be aware of the rationale that's been used. And you know, a lot of times there's prominent not-for-profits who write like white papers and guidances, and those are generally a great place to start for an advocate. But it's always a good idea to go to the source and see what their actual words were. I will add that in legal citation, we do inline citation, not footnotes. So sometimes reading it can be very annoying because it can be very clumped up with citations. It can be like a word, a citation, a word, a citation. And so, yeah, sometimes guidances and white papers from prominent not-for-profits can be really helpful as a jumping off point to understanding the issues. But I will say that there is a whole kind of history, you know, it's based on precedent. Only the Supreme Court can overturn itself in its ruling, but a legislature can change the law, right? There's a famous case. It's a criminal law case. It's about search and seizure. It's called Arizona v. Gantt. And what's really interesting in that case is that the conservative wing of the court, led at that time by Scalia, overturned itself. And Scalia said, the only rationale we need is that we were wrong, because they had predicted certain outcomes that did not come to pass. Basically, Scalia, who never met an indigent criminal he didn't like, which is a very interesting thing about the man, he basically said that under a previous ruling, police were allowed to search a vehicle if they'd already arrested the driver for a different reason, and this was called a search incident to arrest. And he said that search incident to arrest had been so abused that it had totally swallowed the Fourth Amendment and provided a basis for any police officer to search any vehicle at virtually any time. And he's like, that is not the result we intended. We were wrong in our prediction. This ruling needs to be overturned. And so that's a very interesting statement, because we don't always, some members of the court are more attached to the concept of what we call stare decisis. It's a Latinism. It means we hold by what we previously ruled. But other members don't feel that way. So there are certain philosophical approaches and the individual personalities of the individual justices is a topic of much editorializing and analysis in the media and other places. But as an advocate, make sure, I think the benefit to going to the source and reading a Supreme Court case on the issue is that you will be armed with the actual statement of the law. And sometimes the court will suggest, like I said, what the proper solution is, like the legislature needs to change the law, or the state legislatures need to take over this area of the law. The whole issue, like I said, of what belongs in the federal and what belongs in the states, quite a complicated question in the United States, and one that has changed historically over time. I hope that answered your question.
No, that's great. And we have a question here from Yvette Wilkes. She asks, when the Supreme Court is referencing precedent, is it from previous Supreme Court precedent, or is it from another, or is it from other court decisions?
So usually, typically, in our legal system, precedent only travels downward. It doesn't travel upward. Essentially, when the Supreme Court is talking about the precedent that they're following, they're talking about their own precedent. Very, very rarely, they may bring in persuasive sources like international law, certain states that have passed certain laws and what happened. Those are only persuasive things that make people think. They aren't precedent per se. Only the prior cases of the Supreme Court is precedent. But the Supreme Court can look at other sources of law if they are interested in doing that. And when we have oral arguments, part of oral arguments is an attempt to persuade the Supreme Court at what law is important and what law should be controlling in this situation. Sometimes discussing things like negative repercussions, conflict with other laws, procedural issues in enforcement, and other factors that tend to be persuasive rather than controlling. So basically, when you're in a Supreme Court case and they are talking about precedent, they are talking about their own precedent. If you're in a non-Supreme Court case, like let's say you're in a state law case, it could be any court higher than them. So let's say you're at the criminal trial court, they could be talking about the precedent of a state appeals court, a state high court, a federal appeals court, a federal high court. So any of those could be true if you're looking at a lower court case, but when reading a Supreme Court case, they normally cite themselves. Unless they've chosen to adopt persuasive reasoning that came up in the oral arguments or from their own research.
And then we have a question from Dr. Moore, who's wondering if she can use your recording in her social policy course.
If she thinks it will be helpful, I say knock yourself out. I'm also, time and workload permitting, if people are interested in having me speak to their classes, whether it's about practice of law, going to law school, or anything like that, I'm very open to that as long as I have some time to do it. But I remember actually the moment when I first thought about going to law school. I was actually talking to a friend of mine who is a very experienced police officer. And he was explaining the whole premise of roadside frisks and roadside searches. This was under the old rule, right? Before Arizona began, which I was just talking about. And as he was explaining it, I thought to myself, there are systems and some people know how they work. And I said to myself, I want to be a person who knows how the systems work. And I feel like that is not an uncommon situation, especially for younger students. They are thinking to themselves, there are systems out there and they're mysterious, right? Normal people, maybe they can't understand them, or they're thinking that nobody understands them, right? I believe that most people can actually understand them as long as they're stepped through the steps for example, some of the language is obstructive to learning for lay people. And that's one of the reasons why I wanted to have this talk, because there are systems, you are capable of understanding them, but there's a lot of obstructions and obstacles because of the language and the traditions and some of the historical based things that are done. So I would definitely welcome anyone who wants to either share this video with their class or have me talk to people, because it's obviously everybody's relationship with the law is something that I'm very passionate about. And there is a true absence of legal education and civics education in our country right now. And this leads to people not understanding the systems that govern their lives. Thank you for coming to my HU talk.
All right. So do we have any other questions? I don't see any other questions in the chat. But thank Ruth, that's very generous of you to offer to go to classes. I think you'll probably have a lot, be pretty busy.
It's as time permits with my regular duties, but it is something that I enjoy, that I welcome. And I think that in many cases, students who haven't yet reached the level of becoming advocates, or they're thinking about it, they see the law as something that is done to them, whereas in fact it's a system that you can work within, and the way that you work within it is is varied as your goals. So yeah, that's what I would say about that. Thank you all so much. Did I get all the questions that are in the chat?
Yes.
Okay,
yes,
excellent.
You're good. Yeah.
I'll close that off for now. Again, thank you to Carol for her heroically rapid interpretation. And thank you all for your interest. And again, any questions about this? I love to talk about this topic. So I guess that's all.
Thank